Hello friends, I welcome you all my platform, myself Anurag Bharadwaj, and before starting this video, I would convey some certain things. Here we are discussing the fundamental rights. One of the video has been created earlier in which we have talked about basics of the fundamental rights and its type. From now onwards, we will talk about all the articles related to the fundamental rights one by one. Here we are going to start with Article 12. Article 12, that is a definition of a state. So first we shall try to understand what's the meaning of definition of a state and why we have mentioned the word state here under Article 12 at the beginning of Fundamental Rights chapter. So we have to relate this definition of a state with Article 32. What's the relation of 32 and 12? Under Article 32, there is a fundamental right called constitutional remedies, right to constitutional remedies. For that, we have discussed earlier in the video that all the persons, all the citizens as well as non-citizens who have some certain fundamental rights here in the India, in case of violation of their fundamental rights, they can go and visit Supreme Court and High Court. That's called constitutional remedies. But who will violate these fundamental rights? There can be two persons or the entities. One would be individual, second one would be state. State means the government, and that state definition has been mentioned there under Article 12. It means when we talk about the violative entity which is violating the fundamental rights of an individual, then who will be involved in that particular entity would be the part of this definition of a state under Article 12. I think you understood my concept, what I'm trying to convey. Basically, Article 12 deals with all those person or personalities or entities who are going to, or there are chances that they can violate the fundamental rights of an individual, and in that condition that individual can file a case there in the Supreme Court or High Court. These entities have been mentioned there under Article 12. It includes government plus parliament at the central level, government plus state legislature, urban local bodies, Panchayati Raj institutions, all the government entities or all those entities having the share of state or central government. All these entities will fall under the category of states. Let's assume we are, we have a bank called SBI, State Bank of India. That's a nationalized bank. Second bank would be Punjab National Banks, or any kind of mini Ratna or Maharatna company of government of India called PSU, public sector undertakings. All these fall under the category of state. It means in case of violation of the fundamental rights of an individual, if these entities are involved in the violation, then a person can file a suit, file a case there in the Supreme Court or High Court. Is that clear? Second concept is there could be some certain private entities also. Private entities are those which are working under the government for a time being. In that condition, those private entities could also bear the pain of case filled by a particular individual person in case of violation of fundamental rights. It means this Article 12 does not talk about the person or personalities. It talks about those entities which can violate the fundamental rights of an individual, and in that condition there would be a list, namely Parliament and the central government, state government and the state legislature, then the PRI, Panchayati Raj institutions, urban local bodies, all the PSUs, all the PSBs, all those entities where the government has share of 50 or 51%, more than 50%, and along with that all those private entities too having the work or the contract under the government for the time being. In that condition, that entity will also fall under the category of state. But there are some certain institutions which are not the part of this state, namely BCCI. This is one of the very important, Board of Cricket Control of India. This is one of the entity which is completely private. It has no any share of the government and all, and that's why you will see BCCI shall not fall under the category of state. This is one of the examples. Apart from that, lots of examples of private entities are there who are working here in the India but will not cover under the state definition. It means although we can file a suit against them, but they will not be part of state. They will not be part of state. That's a definition of state under Article 12. Then second is Article 13. Article 13 that talks about the laws inconsistent with the fundamental rights. In order to understand this concept, first we will understand some more background part of it. Let's say for example, when we talk about the implementation of constitution, or the date of commencement of the constitution, that is 26th of January 1950. You must have heard about this, you must have known about this date. That is the Republic Day of India, on which we implemented our constitution. We have started commencement of the constitution. This is the date. Before this date, there were some certain laws prevailed there in the India. For example, there were some certain beliefs, there were some certain ideas, faiths, laws, bylaws, or we can say rules prevailed there in the Indian territories, made by either the British government or the princely states or other states or territories. So these laws were prevailed there in the India, and at the time of the commencement of the Indian constitution, when those laws were also there in the India, there were chances that those older laws can or could intervene or violate the fundamental rights of an individual. In that condition, the special article was added to the constitution, that is laws inconsistent with the fundamental right. It has some certain clause. Let's say for example, article 13(1) and 13(1) subclause 1 talks about those laws, those prevailed there in the Indian territory before the commencement of the constitution. And laws means any kind of law, bylaw, rules, rituals, faith, belief, idea, anything. Whatever is going on, whatever is prevailing there in the India, if they are inconsistent with the fundamental right, they will be declared zero. It means they will not have the power of implementation. They will not be implemented there in the Indian territory. That is the first clause. It means before the commencement of constitution, whatever was prevailing there in the India in terms of law, everything will be declared zero if they are inconsistent. Inconsistent means if they are not parallel to the fundamental rights, if they are trying to violate the fundamental rights. In that condition, fundamental right will prevail ultimately, and those laws will be declared zero. And who will declare these laws? It's a duty of judiciary that has the ultimate power to declare these laws zero. Second concept is the state. Whenever the state is going, the second clause is the state shall not make any kind of law which is not consistent with the fundamental right. It means if the state is going to make any law, if the state is going to frame any law, in that condition those laws must be consistent with the fundamental right. If they are not, in that condition too, it's a power of judiciary to declare all those laws zero or nullify all those laws. And this power of the judiciary, this indirect power of the judiciary, is known as judicial review. Judicial review means the judiciary has power, or judiciary has one of the function to read or review all the laws made by parliament or the state legislature or any other entity mentioned there under article 12, and all those entities and the laws, if those laws are inconsistent with the fundamental rights, such laws will be declared zero or nullified by this judiciary, either Supreme Court or High Court. So this power is known as judicial review, which is an indirectly power given under article 30. Here comes two doctrine of judiciary that were evolved due course of time, and these doctrines are doctrines of severability and doctrines of eclipse. These are the two doctrines under article 13 that were evolved due course of time. The first one is doctrines of severability or doctrines of separation, and second one is doctrine of eclipse. I will try to explain this one in a very layman terms and conditions so that you will get it properly. First, doctrine of severability is a kind of doctrine where we talk about separation of that part of law which is inconsistent with the fundamental right, not the whole law. Let's say for example, there is a law having 5 clauses, namely A, B, C, D and E. Let's assume there is a law having 5 clauses, namely A, B, C, D and E, and all these clauses are consistent with the fundamental right except the one which is clause E. Let's assume a law has total 5 clauses, namely A, B, C, D and D, and all these clauses are consistent with the fundamental right except only one called E. So in that condition, the Supreme Court or the judiciary shall not nullify or declare zero all the law, that in that condition the Supreme Court or judiciary shall declare only rotten part or inconsistent part 0, while rest of the law or rest of the clauses of the law shall remain continuously, shall be retained by the state. What does that mean? Let's assume one of the let's assume one rotten apple. So you must have seen that if we are going to consume that rotten apple, if we are going to consume that apple, we will remove that rotten part of the apple. Same goes here with the laws. If there is any part of the law which is inconsistent with the fundamental rights, in that condition, we will remove that inconsistent part only, and consistent part will remain there in the law, will remain there in the, it will retain by the state. That's our doctrine of severability or doctrine of separation. Second is doctrine of eclipse. Doctrine of eclipse has one of the very basic doctrine. Let's assume there is a law prevailed here in the India which is important, but due course of time it is going to it is going to be inconsistent with the fundamental right. So for the time being, till that fundamental right shall prevail, that particular law shall be declared suspended, not nullified, not zero. That law shall be declared suspended till the date when the fundamental right shall remain, and at the date when the fundamental right shall be removed permanently, that right will again be implemented there in the India. As we have seen earlier there in the future part, that all the fundamental rights are non-permanent in the nature, that these fundamental rights can be removed at any time by the Parliament of India, and this particular doctrine has been taken from that part only. It means when the fundamental rights are in the prevalence, in that condition, the law which is inconsistent with the fundamental right but important from the point of view of the citizens, that law shall be declared suspended for a time being, and then when the fundamental right has been removed permanently, this particular law shall continue in implementation. This doctrine is known as doctrine of eclipse. Is that clear? Most of the right to property related laws fall under the category of doctrine of eclipse, that were suspended there at the time of when right to property was one of the fundamental right under Article 31. So for doctrine of eclipse, there is a saying called suspended but not deleted. Suspended but not deleted. It means it will not be deleted. It will not be deleted permanently. They will be suspended till the date when the fundamental rights are in prevalence. The day when fundamental rights will be removed, they will automatically be implemented there in the territory. That's a doctrine of eclipse associated with Article 13 of Indian Constitution. So consistency and inconsistency of a law with respect to the fundamental rights shall be defined or identified by the judiciary only, and this power of the judiciary is known as judicial review. So finally, let's continue the fundamental right chapter, and the first fundamental right, as we have discussed earlier too, the first fundamental right is right to equality. One of the very basic, one of the very important fundamental right which talks about equality. Equality means all the people, whether irrespective of their caste, religion, race, sex, place of birth, residence, whatever, irrespective of their any kinds of we can say any kinds of factor, all the people living here in the India shall be treated as equal. That's a concept of right to equality. This is one of the very comprehensive fundamental right, having total 5 articles from Article 14 to 18. It has total 5 articles from Article 14 to 18. And out of all 6 fundamental rights, this is the most comprehensive fundamental right, as it has total 5 different articles. So let's start. The first article is Article 14. Article 14 talks about equality before law. Equality before law. The state shall treat all the people equally before law. A state shall not make any kind of discrimination against the people in order to maintain the equality before law. We will try to understand this part with the help of some certain kinds of example. Let's assume you must have seen the Lady Justice. Recently, the statue of Lady Justice has been changed. This Lady Justice, initially, the Lady Justice was blindfolded, and along with that, there was a sword in the hand of that Lady Justice, and on the other hand, it was a kind of like scale that was held by this Lady Justice. What does that mean? Irrespective of your caste, irrespective of your class, irrespective of your value there in the society, each and every person shall be declared equal before the law. Suppose if there is a poor person or a rich person, both are moving towards the court in order to get the justice. In both the condition, justice shall be served equally. There shall not be any kind of discrimination with these people. That's called equality before law. But there are some glitches in this particular concept. Reason being, equality before law sometimes talks about that, there is a kind of Hindi saying called sabhi ko ek lathi se hankna. What does that mean? If a person is going to serve justice equally, irrespective of their condition, irrespective of the empathy or the sympathy associated with those people, in that condition, absolute justice shall not be served properly. It means if we are going to provide justice all the persons equally, there shall be some certain kinds of glitches, there shall be some certain kinds of, like we can say, lacunas that shall not be fulfilled at all the conditions. So first we will try to understand this concept, then we will talk about this. Equality before law has two concepts, namely equality before law and equal protection of law. Equality before law and equal protection of law. Equality before law talks about equality. It means the lady justice is blindfolded, like it's not going to see anybody there in the society. Whosoever is coming, the justice shall be served irrespective of their class, caste, whatever. But here you will see there may be some certain kinds of persons who have committed crimes habitually, while there may be some certain kinds of persons who have committed crime, basically based on their situation or the condition. Let's assume a person who has who has robbed a particular shopkeeper because he was very hungry. In that condition, we cannot compare that person with that habitual offender who is robbing shops because of his or her habits. In that condition, when the judiciary is going to serve justice, the judiciary shall treat both the persons equally, while there shall not be any kinds of vacuum for conditional crimes or habitual crimes. So that's why we can say that the equality before law is very narrower law, narrower concept. Why the narrower concept? Because it talks about the equality, absolute equality, irrespective of the condition of the crime, irrespective of any kinds of condition, and that's why we will say it talks about the equality. So let's assume if you are in a school where there are two classes, namely 5th class and 10th class, and you are going to frame a question paper of mathematics of 10th class, and you have declared that all the class students are going to participate in that exam. So what do you think that is it possible that the 5th class student will score better there in that examination? No, it's not possible. The same goes with that concept. Let's say, for example, again, if a child is committing a crime and an adult is committing a crime, in equality before law concept, the law, or we can say the judiciary, shall serve justice equally, irrespective of their age, irrespective of their gender, irrespective of their society background. That's why the new concept of equal protection of law was introduced, and this concept has been taken from America. This one is the concept of UK, United Kingdom. There is a book of a person called Rule of Law. So this concept has been taken from Rule of Law of A.B. Dicey, who was one of the, we can say a politician there, thinker there. And in this Rule of Law, there was a concept of equality before law that had been taken from UK. While the original, or we can say modern concept, is equal protection of law. And this equal protection of law talks about the condition, or we can say situation of the commencement of the crime. Let's say, for example, again, if a lady is committing a crime, there must be some certain situations under which that lady was pressurized, or under which the lady was committed that crime. While there is a habitual offender who is committing a crime, both would be different, and in that condition, justice shall be different to both the persons. It would not be same to all, it would be different as per the condition of the commencement of crime. That's called equal protection of law. It means when the government or the state is going to frame the policy, irrespective of the society, irrespective of the different factors of the society, that would be the part of equality before law. While when the government is going to choose the societal part or the community and framing the law according to that, in that condition it would be treated as equal protection of law. It means the reservation scheme or different kinds of policies and programs made by the government of India for the upliftment of the women and the children shall part of this equal protection of law, while when the government is going to make a kind of universal program to all, that would be the part of equality before law. This is the UK concept, this is the USA concept. This one is negative in nature because it talks about equality, absolute equality irrespective of condition, while this is positive in nature because it's a kind of modern law that talks about the equality along with the situation or the condition. And that's why this is one of the very comprehensive. That's why this concept is one of the very comprehensive concept where it provides the reservation schemes or the upliftment scheme of a particular vulnerable section of the society. So I hope it would be clear in your mind. There are two concepts under Article 14, equality before law and equal protection of law. Equality before law talks about the absolute equality, but it talks about, we can say, relative equality or the conditional equality. Now we will see next article, Article 15. Article 15 talks about the prohibition of discrimination on some certain grounds. All kinds of discrimination shall be prohibited on some certain grounds, and these grounds are religion, race, caste, sex, and place of birth. These grounds are religion, race, caste, sex, and place of birth. It means on these 5 grounds only is the word that has been mentioned there in the Constitution. Only on these 5 grounds, nobody shall be discriminated here in the India. It means apart from these 5 grounds, there can be some certain other grounds on which their discrimination can be made, discrimination can be maintained by the state or the individual. It means, what does that mean? These are the only 5 fixed ground on which discrimination shall not be entertained here in the India, and apart from these 5 grounds, other grounds are open to discriminate there in the Indian territory. That's a kind of, like, we can say, interpretation of this particular article. It talks about the prohibition of discrimination on these grounds. It means an individual can never be discriminated on the grounds of their religion, race, sex, caste, or place of birth. 5 grounds only. It means apart from that, discrimination can be made. One more thing here. Here there are some certain clauses, namely 15.1, 15.2. 15.1 talks about state and 15.2 talks about individual. It means the state shall not discriminate among the people on the behalf of, on the grounds of those 5 grounds what we have mentioned earlier, namely religion, race, caste, sex, and place of birth only. It means apart from 5 grounds, the state can discriminate. Same goes with the individual. Individual shall also not discriminate with the people on the grounds, on those 5 grounds, again, namely religion, race, sex, caste, and place of birth. It means individual also open to discriminate the people apart from those 5 grounds, they can discriminate. Keep it in your mind. One of the important. Apart from that, 15.3, 15.4, 15.5 and 15.6. These 4 exceptions were added later by the state or the parliament under Article 15. This Article 15.3 talks about women and children. Nothing in this article shall prevent the state in making the laws related to the upliftment of women and children, and it shall not be declared or considered as discrimination. It means if the government is going to make some certain laws with respect to the women and children, or in order to uplift the women and children there in the India, such kind of law shall be prevailed there in the India, whether they are consistent or inconsistent with the fundamental right, whether they are promoting justice or not, but these programs and the policy shall prevail there in the India under Article 15.3. Article 15.4 and 5 talks about socially and educationally backwardness plus to communities SCs and STs. It talks that Article 15, subclause 5 and 4, subclause 4 and 5, that talks about socially and educationally backwardness and the communities called STs and STs. Nothing in this article, Article 15.4 states that nothing in this article, nothing under Article 15 shall prevail the state in making the laws for the upliftment of socially and educationally backward community and SCs and STs. And Article 15.5 talks about educational institution. Nothing in this article shall prevent the state in making the provision for the upliftment of socially or for the admission of socially and educationally backward community or SCs or STs in the educational institutions. So reservation in the educational institution is a part of Article 15.5 and common policies and programs for SCs and STs is a part of Article 15.4. And here comes, okay, these provisions were added through First Constitutional Amendment Act of 1951. Article 15.4 and 15 subclause 5, these two articles were added through First Constitutional Amendment Act of 1951. Apart from that, you will see that Article 15.6 is 103rd Constitutional Amendment Act of 2019. Article 15.6 was added through 103rd Constitutional Amendment Act of 2019, where it stated that EWS, economic weaker section, now the state has power, now the state has, we can say like function to make some certain rules or to make some certain policies for the upliftment of economic weaker section.